All right. Um, welcome. A very warm welcome to all my listeners, viewers, wherever you are in any part of this world. This is yet another lecture, lecture 12. My name is Professor Dr. Advocate Milton. I hold a PhD degree in international criminal law. My doctoral research revolves basically around the legal and institutional framework of the International Criminal Court. Today, I'm going to take you through the lecture, which revolves on what I covered for my doctoral research. It's a series of lectures that will look at the philosophical approach that I gave to these areas or these topics and the legal and institutional framework of the International Criminal Court. So the lecture for now is the emergence. We want to quickly look at the emergence of the doctrine of complementarity. The emergence of the doctrine of complementarity. Very warm welcome to all my listeners and viewers, wherever you are. And I want to thank you once more. As I said, I'm Professor Dr. Advocate Milton, and this is lecture 12. And I'm going to lead you through the discussion relating to the emergence of the principle of complementarity. Okay, so to begin with, we know that we are trying to drive into this concept of positive complementarity. But to understand what this concept is, we need to get to know how the principle of complementarity itself, the classical principle, emerged. So it's clear we say that the topic positive complementarity is deeply rooted in the principle of complementarity, which is well articulated. Complementarity is well articulated in the Rome Statute. The principle of complementarity within the context of international criminal justice is concerned about the distribution of jurisdiction between the ICC on the one hand and the different national courts, criminal jurisdictions within the national criminal systems. Any attempt at developing a legal framework for positive complementarity, therefore, must begin with analysis of the relevant provisions of the Rome Statute. So here I start by tracing the historical evolution of the principle of complementarity through a description of evolution and distribution of jurisdictional competence between national criminal courts and the international courts and tribunals. The tribunals, as we saw previously considered here, include those ad hoc international military tribunals, which were established after the Second World War, namely the International Criminal Court, the International Military Tribunal for the Nuremberg, and the International Military Tribunal for the Far East, which is ordinarily referred to as the Tokyo Tribunal, as well as the Icty and Ictr, which is simply the International Criminal Tribunal for the former Yugoslavia and International Criminal Tribunal for Rwanda. To be able to explain the context in which the concept of positive complementarity evolved, it is important to understand the nature of the principle of complementarity, as I've just said, and its limitations, not just the nature, but what limitations that has led us to exploring other opportunities, such as the positive complementarity. The analysis of the principle of complementarity provides a background to this discourse of the concept, as we shall see in subsequent chapters. Now, the Nuremberg and the Tokyo International Military Tribunals only discussed here to be able to illustrate the distribution of juridical competence and nothing much more than that. And so the same applies to the historical survey of the Icty, which a term we'll use to refer to the International Criminal Tribunal for former Yugoslavia, and Ictr. All these were looked at with the view to considering the juridical competence. So a historical survey of the military tribunals and ad hoc tribunals, and also like the Sierra Leone Court, are also undertaken to demonstrate the significance of the origin and evolution of the court system that culminated into what we now have as the ICC, the International Criminal Court. Now, eventually, also that now tends to adopt the concept of positive complementarity. Okay, so all this background is essential so that it sheds light. We understand the evolution of the concept of positive complementarity as it comes. This is because it is submitted. I submit that this owes the concept, the evolution of this concept, owes to the existence of certain structural failures within the rigid framework that was provided for under the statute, which formed the basis of the court, the rigid framework under the principle of complementarity. We're talking about two things: positive complementarity as a concept and the principle of complementarity. And we're saying the rigid framework upon which the International Criminal Court and the Rome Statute have rested have generated the desire to be able to explore the concept of positive complementarity. So let's quickly try to see. So an analysis and distribution of the distribution of juridical or jurisdictional competence over a period of time in the evolving jurisdiction provides us, therefore, with a useful background to explain how the concept of positive complementarity came about. The trend that emerges from the work of these of the tribunals that we mentioned, the military tribunals, up to the establishment of now the permanent court, which is the International Criminal Court, may be described in international criminal terms as a shift or transition from primacy to complementarity. So when we look at right from the beginning of the Nuremberg, the military tribunals, the Tokyo, and we look at the Icty, the Ictr, Sierra Leone, we see as it moves towards the ICC, the culmination to ICC, there is something we are seeing here. It is a movement or a shift from primacy into what we call complementarity with the establishment of the International Criminal Court. Why primacy? Primacy because in those other ad hoc tribunals, the exercise of jurisdiction was entirely based upon the primacy of jurisdiction in those tribunals. But we now see a court, the International Criminal Court, where complementarity is the cornerstone. It exists by virtue of the statute, which empowers it to act to complement what the national jurisdictions are able to do. So now let's discuss movement from primacy to complementarity. I want to have a subtopic here from primacy to complementarity. Okay, as a general talk, the principle of complementarity is essentially about jurisdiction and who can exercise jurisdiction in the context of international criminal law. That's all about complementarity. That's what we can say about it. I can summarize it in that form. It's necessary at this point to examine how the rules of general international law deal with the distribution of jurisdiction. And thereafter, we'll be attempting to establish international jurisdiction. We'll discuss that. The ICC is premised on the concept of complementarity, which in effect means that primary responsibility for exercising jurisdiction in respect of international crime rests with the domestic criminal system. However, it should be noted that there is no comprehensive convention obliging states to criminalize and exercise jurisdiction over international crimes at national level. What are we saying? We're saying that the concept of complementarity rests upon the understanding that the priority in terms of exercising jurisdiction rests with the international, with the national criminal jurisdiction, the domestic criminal systems. That is where it starts from. That's where it should start. That is a very important principle that has to be explained. However, what we are trying to argue is that, notwithstanding what we just mentioned, there's nothing internationally which obliges those national states to be able to carry out or exercise jurisdiction. even though the primacy of such jurisdiction rests upon the domestic criminal system. So there we are. So the national jurisdictions are at liberty whether to exercise or not to exercise. That is where now the International Criminal Court either encourages them through positive complementarity or takes over the issue, the responsibility of exercise of jurisdiction to ensure that impunity is arrested. There are two approaches to state jurisdiction under public international law. The first allows states to exercise jurisdiction as they see fit, unless there is prohibitive rule to the contrary. That's one theory. The state should be able to exercise jurisdiction in any manner they consider appropriate, unless really there is a rule that stops them from such exercise. And the second theory or approach is that the states are prohibited from exercising jurisdiction unless there is a permissive rule that allows them to do so. Yeah. This one, there's one negative approach, one is a positive approach. Okay, under the latter approach, the permissive rule, states are not authorized to exercise their national jurisdiction unless they can rely on permissive principles. And those principles are one, territoriality, personality, protection, and universality. These are four key principles in terms of exercise of national jurisdiction, permissive principles. Okay, well, the territoriality principle can be viewed as either subjective or objective. It is subjective where the state has the power to exercise its criminal jurisdiction or authority within its national territory. You can look at Brown, discussion of Brown on this matter in Lowry in American Journal of International Law, 1981. The 75 American Journal of International Law at page 257 and 236. You would see more analysis of this. The territoriality principle is objective, where the state has jurisdiction over extraterritorial conduct which has an injurious effect on its territory. This sometimes is referred to as the effects jurisdiction. Under the customary international law, territoriality serves as the basic principle of jurisdiction. However, in exceptional circumstances, national laws may be given extra territorial application, provided the national laws can be justified by one of the recognized principles of extraterritorial jurisdiction under public international law. All right. Whereas under nationality principle, remember there's a nationality principle, a state may exercise jurisdiction over its nationals and their conduct, irrespective of whether they are in or outside the territory. That is nationality principle. Whereas that is what nationality principle does. In the passive personality principle, this arises where a state exercises jurisdiction over acts committed by non-nationals, but where the victim is a national of a prosecuting state. So we have one situation. The court, the national jurisdiction is empowered to exercise jurisdiction upon the personality, a person, irrespective if that person is a national of the country where the court sits, the national court has exercises jurisdiction. So wherever this particular crime is committed is immaterial. It's only that it has control over that person. But then we have also seen that, on the other hand, there is a very passive personality principle where the jurisdiction is exercised, where even a non-national has committed an offense and the victim happens to be a national. So that empowers us under passive nationality principle to be able to exercise jurisdiction over that particular person. Then we have the protective personality principle, which allows a state to exercise jurisdiction over the conduct outside of its borders, but which threaten its security. So if a conduct is across the border, but it has the net effect of threatening the security of a state, it may have jurisdiction irrespective of whether the conduct was outside its border, if it can threaten its security. While the principle of universality recognizes that the conduct outside its national borders is a danger to the state and its national. We may have guerrilla activities being formulated outside that being planned that would eventually, if there's an incursion, lead to massive deaths and destruction of property, loss of lives. Then we say that under this particular universality principle, the state would have jurisdiction. So, against this background, the question of juridical competence emerges as very critical and important. In an era without international tribunals, where there were no national courts, that time national courts did not only have primacy of jurisdiction, but also had the sole jurisdiction over criminal acts. So we can see, in the absence of international structures or tribunals, then all the sole responsibility rests upon the national courts. Therefore, it was states, whether exercising jurisdiction based on territoriality, nationality, or personality, or protective personality, that it is the states that were responsible for the prosecution of offenses exclusively. So, without international criminal tribunals, the issue of the distribution of jurisdiction between international tribunals and domestic courts did not arise. The only issue involving the distribution of juridical competence that may have arisen concerned the horizontal distribution between states inter se. That means it's between the states. That was the issue alone that now became of importance. On that note, we proceed to look at, let's look at the international military tribunals. The international military tribunals. A consideration of establishment and functions of the United Nations War Crimes Commission, set up just on the 20th October 1943, provides us with a background against which to analyze international military tribunals. I'll call this United Nations War Crimes Commission UNWCC. In short, the UNWCC was primarily a fact-finding body which performed advisory functions for the development of the principles of international law and planning for international tribunals. The UNWCC was established to collect, investigate, and record evidence of war and to identify, where possible, the individuals responsible for certain activities or certain offenses. However, this particular commission had no power to prosecute suspected war criminals and could only report back to the United Nations members. It was then incumbent upon the governments of the member states of the UNWCC to convene a tribunal, such as the International Military Tribunal of the Nuremberg, which would then prosecute the offenders. Against this backdrop, the nature and jurisdiction of the International Military Tribunal are now discussed. We shall proceed to discuss the two of them. We have the Nuremberg and the Tokyo Military Tribunal. These were designed to address atrocious crimes committed during the Second World War. The origins, composition, and jurisdiction of the Nuremberg and Tokyo tribunals differ in several significant respects. This survey now provides that I'm delving into, begins by looking at, as I said, the International Military Tribunal for Tokyo and the International Military Tribunal for Nuremberg. Okay, let's start off with the Nuremberg International Military Tribunal for the Nuremberg. We'll shortly just call it the IMT Nuremberg. The IMT Nuremberg was product of victory in war in the early winter of 1942, the government of the Allied powers, that is the victors, the United States of America, Great Britain, France, and the Soviet Union, these four states had emerged victorious in the Second World War. You see, the victors, it's like the victors, we've heard of the victors, justice. They announced in a joint statement from a palace of St. James in London, the United Kingdom, the famous statement referred to as the St. James Joint Statement, their intention to prosecute and punish the Nazi war criminals. The St. James Joint Statement affirmed the determination of the Allied powers to prosecute those responsible for violent crimes against civilian population during the Second World War. In the statement, Germany's policy of aggression was condemned. They vehemently condemned this policy, and the statement announced that the participating governments placed among their principal war aims the punishment through the channels of organized justice of those guilty of and responsible for these crimes, whether they have ordered them, perpetrated them, or participated in them. So we can see that the statement shows that the international community had begun to recognize the need for an organized form of international criminal justice to enforce the criminal law at an international level. So the need to mete out justice for criminal offenses, of course, raises the prospect of potential competition between national jurisdiction and international entities established for this purpose. It is this potential competition that necessitates some framework for distribution of juridical competence. So in October 1943, the Moscow Declaration was signed by the three main powers represented by the British Prime Minister Winston Churchill, the Soviet Union Joseph Stalin, and the President of the United States of America Franklin D. Roosevelt. The essence of that declaration was that when armistice was signed, persons deemed responsible for war crimes would be returned to those territories in which the crimes had been committed and would be judged according to the laws of the nation concerned. This is reminiscent of the nationality principle in international criminal justice and served to emphasize the primacy of national jurisdiction. The leaders further resolved that the major war criminals whose crimes could not be assigned to any particular geographical location would be punished by joint decisions of the Allied government. You see, now we begin to have a joint approach to administration of justice. The distribution of competence in this context involved, it is submitted, the allocation of jurisdiction to identified competent adjudicating authorities. This allocation, however, does not necessarily grant primacy to international tribunals. The resolution underscored the significance of a concerted effort by members of the international community to combat impunity. We can see this starting to feature now, that the joint concerted approach to face impunity. It is submitted that the element of complementarity, as understood in the context of the Rome Statute, was absent from this new development. So nothing featured that would give a semblance of the principle of complementarity as we know it right now at that point in that concerted approach. Notwithstanding that certain political leaders advocated for the summary execution of Nazi war criminals rather than subjecting the criminals to trial, ultimately the Allied powers settled for a formal trial process to determine the guilt of the accused. This represents a shift in attitude by way of Allied powers from summary execution to prosecution and trial, in which proof of guilt of the accused was accepted as a requirement for punishment. Okay, so now we're seeing an organized form of justice where there was no punishment unless there has been the right to try invoked, and that proof has been established that someone is guilty. And in this shift, we see the origins of international criminal justice at the hands of an international tribunal, a process which also gave rise to the question of distribution of juridical competence. Okay, in August 1945, soon after the end of the Second World War, the four major powers which had emerged victorious signed, they had emerged victorious in 1945. Remember that at the end of the World War, Second World War. So they signed the London Agreement, effectively establishing the IMT Nuremberg, the International Military Tribunal for Nuremberg, to deal with, to prosecute and punish the major war criminals of the European Axis. The focus at this point appears to have been largely on war crimes, but elements of crimes against humanity were also prosecuted by the tribunal. So additional countries subsequently adhered to the London Agreement to show their support for the fight against impunity. These countries included Australia, Belgium, Slovakia, Denmark, Ethiopia, Greece, Haiti, Honduras, India, Luxembourg, the Netherlands, New Zealand, Norway, Panama, Paraguay, Uruguay, and Yugoslavia. This was a clear demonstration that the idea of the international criminal justice through the trial of suspected war criminals by international tribunals was increasingly gaining favor among the major states of the world in post-war era. The IMT Nuremberg's constitution, function, and jurisdiction were outlined in the Charter of the International Military Tribunal. So there was a charter of the IMT, the Nuremberg Charter, we refer to it as the Nuremberg Charter, which set out how the tribunal would be constituted, its functions, its powers in terms of jurisdiction. So this was annexed to the London Agreement of 1945. So the Nuremberg Charter provided that the tribunal had authority to try and punish persons who committed any of the following crimes, which were listed, and they were listed as crimes against peace, war crime, and crimes against humanity. All right, the trials of the German leaders before the IMT Nuremberg for the post-war crimes officially commenced in Nuremberg, Germany on the 20th November 1945. The IMT Nuremberg represented the genesis of international criminal law. That's very critical to note. The beginning of the international criminal law can be traced to the IMT Nuremberg proceedings. The Nuremberg trial had a significant impact on the development of international criminal law, as we said, including the issue of distribution of juridical competence between national and international tribunals. The IMT Nuremberg presided over the joint trial of senior Nazi political officials and military authorities, as well as several Nazi organizations, for war crimes and other wartime atrocities that were committed. These trials of Nazi leaders represented the first serious prosecution of international crimes at the international level before an internationally constituted tribunal. So we can see the picture of an international form of justice system evolving with the advent of the International Military Tribunal for the Nuremberg. What to note, on the 18th of October 1945, 24 top Nazi political and military leaders were arraigned before the IMT Nuremberg. The Nazi leaders charged included Hermann Göring, Rudolf, Alfred Rosenberg, Albert Speer. The Nazi military dictator Adolf Hitler avoided indictment by allegedly committing suicide in April 1945 during the final moments of Japanese surrender. It can be seen from the above list of indictees that indeed the IMT Nuremberg concerned the prosecution of high-profile suspected offenders. 4 charges brought against the Nazi officials arraigned for the trial before the IMT Nuremberg were war crimes, crimes against peace, crimes against humanity, and conspiracy to commit these crimes. So these were the key elements of that Greek crimes that whose elements constituted the process of prosecution before the IMT. It should be noted that the Rome Statute also provides for the prosecution of certain similar crimes, specifically crimes against humanity, with different elements, of course, crimes of aggression, genocide, and war crimes. So these serious crimes were already subject to prosecution as early as at the inception of the IMT Nuremberg. So the Nuremberg Trials lasted from November 1945 way up to October 1946, almost 1 year. About a year. The IMT Nuremberg invariably prosecuted prominent members of the Nazi regime who were suspected of having orchestrated or participated in the Holocaust and war crimes. These were personalities who controlled the government system and power, and it was consequently not possible for the German state machinery to bring them to trial without devastating repercussions. So all that we could have is an internationally constituted tribunal coming. So it was not easy. That's one question where there would be unwillingness to be able to prosecute the Nazi leaders. As we said, it was not possible for Germany itself to prosecute its own offenders who are high ranking. Instead, there had to be an international independent body to look into the prosecution issue. The distribution of juridical competence emerges as an important factor here, in that the IMT Nuremberg focused on serious international crimes, so that actually gives a different identity into this argument. We'll now next focus on the Tokyo war crimes trial and the other military tribunals addressed to see what contributions they made to fight impunity. So the next, we are now going to look at the International Military Tribunal for the Far East, also known as the Tokyo Tribunal. The IMT Nuremberg was followed by the lesser-known IMT for the Far East, which is the Tokyo Tribunal, which was established in Tokyo, Japan on 19th January 1946. Although it only convened for the first time in April, almost 4 months later, 29th April 1946. The charter essentially set out the laws and procedures by which Tokyo trials were to be conducted. Unlike the IMT Nuremberg, which was set up by the four Allied powers, the Tokyo Tribunal was set up by individual initiatives of the United States General Douglas MacArthur, who was the Supreme Commander of the Allied forces in occupied Japan, who issued a special proclamation establishing the tribunal. This was an individual, not states. MacArthur approved the Charter of the Tokyo Tribunal, referred to as the Tokyo Charter, on the same day he issued the proclamation. To this extent, the Tokyo Tribunal differs from the ICC, which was created by way of a treaty adopted multilaterally by the states. The question arising here is, of course, whether, given the facts of its establishment, the Tokyo Tribunal can truly be regarded as an international tribunal. This is debatable. Nonetheless, on the 6th of October 1945, MacArthur received a directive, subsequently endorsed by the other Allied powers, granting him the authority to proceed with the major trials and giving him basic guidelines for their conduct. The Tokyo Tribunal presided over by a series of international trials of senior Japanese politicians, military personnel, pursuant to its authority to try and punish Far East war criminals who are convicted. The prosecution team of the Tokyo Tribunal consisted of judges from 11 Allied powers, nonetheless. So these were mainly from Australia, Canada, China, France, Soviet Union, Philippines, New Zealand, Netherlands, India, Great Britain. So these judges came from this country, for all those countries, to give it semblance of identity of an international character. The Tokyo Tribunal, like the IMT Nuremberg, provided a basis for the distribution of judicial competence, in terms of which the focus of international tribunals was on serious crimes, while less serious crimes were left to the national courts of the relevant states. So we can see the impunity gap argument coming in here. So the Tokyo Tribunal also concentrated on higher degree offenders and left the lesser ranking offenders to the respective national jurisdictions. Okay, having looked at those two, what are the conclusions we draw? The IMT Nuremberg and the Tokyo Tribunal did not use the principle of complementarity in their trials. The trials proceeded before the military tribunals, irrespective of the consent or concurrence of the national states, as there had been a complete breakdown in systems of most national courts of those states. So it didn't matter whether a state would claim that it has primacy or it has carried out investigations and or trials. The tribunals just proceeded. So the principle of complementarity was largely absent. So the International Military Tribunal essentially exercised sole jurisdiction. They enjoyed, therefore, jurisdictional primacy and had no need to seek prior approval or compliance before they could exercise criminal jurisdiction over any suspect arraigned before them. The exercise of primary jurisdiction is one feature which distinguishes international military tribunals from the ICC. The historical survey of these courts is therefore important in providing the background to understand the evolution of the concept of positive complementarity. In a similar vein, the exercise of jurisdiction by the international military tribunals differed from the basis of jurisdiction exercised later by the ad hoc international criminal tribunals, as will be indicated in the next discussion as we proceed. Okay, now we proceed to discuss the ad hoc international criminal tribunals. After the mayhem of the Second World War during the 1940s, the international criminal justice actually became a matter of urgent concern to the international community. Shocking atrocities perpetrated in Rwanda and the former Yugoslavia again attracted renewed attention of the world to the kind of criminal devastating activities going on. The mass killings in these two regions consequently resulted in the establishment of the ad hoc tribunals to deal urgently with cases arising from the atrocities. This discussion, therefore, examines the ad hoc criminal tribunals, which were set up to deal with the rapidly deteriorating situations in those two territories. The last quarter of the 20th century witnessed significant developments in international criminal law. This period saw the creation of two ad hoc international criminal tribunals, namely the International Criminal Tribunal for former Yugoslavia, ICTY, and the International Criminal Tribunal for Rwanda, which we refer to as the ICTR. The creation of these two tribunals represents a significant step forward in terms of the interpretation and implementation of the principles of international criminal law. Equally significant is the fact that the ICTY and the ICTR represent a post-Cold War emerging international consensus. There was a consensus emerging at the post-Cold War period on how to hold individuals accountable for atrocities committed. We see that the United Nations Security Council set up the ICTY and the ICTR in 1993 and 1994 respectively, by way of resolutions adopted under Chapter 7 of the UN Charter. So we see now that unlike the other tribunals, other tribunals like the Nuremberg, these two particular tribunals, the ICTY and the ICTR, were established by way of the United Nations Security Council resolution under the auspices of Chapter 7 of the United Nations Charter. In terms of the international criminal tribunals, the terms they were tailored. Those international criminal tribunals were tailored or made in such a way for situations. They were mandated to address the situations in the former Yugoslavia and Rwanda, respectively. So the resolution was made targeting the creation of the former Yugoslavia to deal with the specifics that emerged from the former Yugoslavia situation. Similarly, the Rwanda situation, the Ictr was coached. The creation and design and empowering was designed in such a way as to deal specifically with the Rwandan situation on an ad hoc manner. So let's start off with the International Criminal Tribunal for the former Yugoslavia. I've dealt with this in a separate discussion previous lecture, when looking at the structure of the International Criminal Court, but I'm going to quickly get into this as it's part of the concept of the evolution of the concept of complementarity. So let's look at the International Criminal Tribunal for the former Yugoslavia, the one we said is abbreviated as ICTY. The ICTY was created as an ad hoc entity to deal with the unique and deteriorating security situation in the former Yugoslavia. It is an ad hoc. It's an ad hoc in that it was intended to be temporary, and once the situation for which it was established had been resolved, the mandate would have to fall away. Meaning the design, it was just ad hoc to perform specific functions in specific areas, and as soon as those functions were executed, this mandate would fall away. The armed conflict in the former Yugoslavia had a dual character, in that the war was, on the one hand, an international war between the former Yugoslavian Republic of Bosnia-Herzegovina, Croatia, and Serbia, while on the other hand, it was also an internal conflict between the different Bosnian ethnic groups, the Croats, the Serbs, and the Muslims, who are within the Bosnia-Herzegovina. So it was a very confused kind of conflict. Whether one chooses to describe the conflict as an international or international, ultimately it was essentially an ethnic-based conflict. We look at it as revolving basically around the element of conflict, ethnic consideration of conflict in conflict. The humanitarian disaster resulting from the conflict in former Yugoslavia, thus Croatia, and within the Federal Republic of Yugoslavia, demanded immediate attention of the international community. The situation was rapidly deteriorating. So against the background of mass killings and other atrocities, the ICTY was immediately established to prosecute the perpetrators of the atrocities as a way of deterring and arresting the situation. The statute of the ICTY provided the legal framework for the prosecution and punishment of criminals involved in these violent conflicts. Specifically, Article 9 of the statute of the ICTY prescribed the relationship between the national courts and the tribunal by granting the latter, that's the tribunal, primacy over the former. So this is where primacy was granted to an external tribunal, an international tribunal, as opposed to the case of a national court having primacy, as we know it under the principle of complementarity. What does Article 9 say? Let's read it. It says the international tribunal and national courts shall have concurrent jurisdiction to prosecute persons for serious violations of international humanitarian law committed in the territories of former Yugoslavia since the 1st of January 1991. Concurrent jurisdiction. Note that. Paragraph 2, the international tribunal shall have primacy over national courts. Primacy over national courts. At any stage of this procedure, the international tribunal may formally request national courts to defer to the competence of the international tribunal in accordance with the present statute and the rules of procedure and evidence of the international tribunal. Okay, while Article 1 9, paragraph 1 makes it clear that the ICTY will enjoy primacy of jurisdiction over the national courts. The statute also expressly retains the concurrent jurisdiction of national courts. Yeah. Actually, Article 2, paragraph 2 of Article 9 makes it clear that there is primacy that's conferred upon the tribunal as opposed to the national courts. And we see the concurrence of jurisdiction as well. The precise nature of the relationship between the domestic courts and the ICTY, reflecting both concurrence and primacy, emerges from the ability of the ICTY at any stage in the procedure to just formally request the national courts to defer to its competence as set out in Article 9, paragraph 2. The jurisdictional primacy as expressed in the ICTY's statute and rules of procedure is exercised by ICTY as a judicial discretion. So there's discretion upon it to exercise that particular competence or primacy. Consequently, the jurisdiction of the ICTY is grounded in the United Nations Security Council enforcement measures rather than the consent of the states, as would be the case with tribunals such as the ICC created in terms of the treaty. The fact that the creation of the ICT flowed from the United Nations Security Council resolution impacts on its juridical competence, in that the United Nations Security Council specifically allocated juridical competence to the creature of the statute of the ICTY. This resolved the issue of allocation of juridical competence between the ICTY and the national courts. The ICTY was established amid heated debates as to whether Chapter 7 of the Charter of the United Nations include the power to establish a court or judicial system. This was a debate. This debate was effectively resolved by the ruling of the ICTY Appeals Chamber itself in the case of Prosecutor versus Turdic, a decision on the defense motion for the interlocutory appeal on jurisdiction. Briefly, in the appeal case, the appeals chamber ruled that the ICTY was empowered to pronounce on the plea challenging the legality of the establishment of the tribunal. To begin with, the appellant had argued inter alia that the establishment of such an international criminal tribunal had not been contemplated by the framers of the United Nations Security Council as one of the measures specified under Chapter 7, United Nations Charter. The appellant further contended that the United Nations Security Council was constitutionally and inherently incapable of creating a judicial organ, as it was conceived in the United Nations Charter as an executive organ, and so did not have judicial powers which could be exercised through a subsidiary organ. The appeals chamber dismissed the challenge to the primacy of the ICTY over national criminal courts. This ruling was in response to the challenge by the defendant to the jurisdiction of the ICTY on the second ground that the primacy over national courts, which Security Council Resolution 827 purported to give to the tribunal, was unlawful. Okay, the chamber accordingly ruled that the ICTY enjoyed subject matter jurisdiction over the case before it. In sum, therefore, the appeals chamber held the establishment of the ICTY fell squarely within the powers of the United Nations Security Council in terms of Article 41 of the United Nations Charter. For these reasons, the appeals chamber concluded that the ICTY had been lawfully established as a measure under Chapter 7 of the United Nations Charter. So notwithstanding the primacy of its jurisdiction as I've just explained, the ICTY has referred certain cases to national criminal courts in accordance with the so-called completion strategy for tribunal. That we know the IMT, the mechanism that winds up the matters between those tribunals. The completion strategy was designed to ensure a phased and coordinated completion of the work of the ICTY by 2010. The ICTY was, however, unable to meet this tight timetable and was compelled to notify the Security Council that all trials were expected to be completed end of 2012. In reality, the ICTY only completed its last full trial, the Rattler-Maldi case, in December 2016, and this case is still open for appeal. Accordingly, the United Nations Security Council unanimously adopted Resolution 2329, which effectively extended the ICTY mandate and the terms of its ICTY judges to 30th November 2017, or until completion of their cases. So the completion strategy enabled the ICTY to shift focus to the so-called high-profile offenders, while leaving the less ranking suspects to be dealt with by the national courts in Bosnia-Herzegovina or other national jurisdiction competent to try the case. This is in line with the principle of primacy, in that the ICTY which determines, it is the ICTY which determines the jurisdiction. The strategy of referring cases to national criminal courts effectively reinforces the capacity of national courts to handle core international criminal cases. The following section turns to the background. I'll look at the background too and the basis for jurisdiction of the other twin ad hoc International Criminal Tribunal, namely the International Criminal Tribunal for Rwanda. So let's quickly get through the International Tribunal for Rwanda. And after looking at that, that will bring us to the end of this section of the discussion. Okay, the International Criminal Tribunal for the Rwanda, which we said is the ICTR, this is what we have to observe. The insecurity and rapidly deteriorating humanitarian situation in Rwanda necessitated the intervention of the international community to redress the atrocities visited upon innocent civilian population in the Central African state. Unlike the atrocities in the former Yugoslavia, Rwandan conflict was essentially an internal conflict. Rwanda, as Rwanda-Urundi, was placed under Belgian rule, both under mandate of the League of Nations between 1916 and 1945. And United Nations Trust Territory 1945 up to 1961. In 1961, the Belgian rulers organized parliamentary election in which the Hutu majority won most of the mayoral seats. This election outcome sparked conflict, which led to some of the defeated Tutsis fleeing into exile. The exiled Tutsis organized themselves as a liberation movement and launched a military invasion using paramilitary wing, the Rwanda Patriotic Front, led by Paul Kagame. Owing to the pressure of incessant military incursions into Rwanda, the Arusha Peace Accords were signed between the RPF, that's the Rwanda Patriotic Front, and the Rwandan government in August 1993. The accord provided for a transitional power sharing deal between the RPF and the elites among the majority of the Hutu in power. So in 1994, Rwandan genocide involved the mass killing of between 500,000 and 900,000, almost a million, Tutsi Rwandese, politically moderate Hutus, by a gang of Hutu extremists. So there were a gang of Hutu extremist military, police, and personnel who were actually being directed by the Hutu government to massacre not only the Tutsis but also the moderate Hutus. The killing started in April 1994, immediately after the signing of the peace agreement creating democratic institutions in Rwanda. The genocide continued after the peace agreement for some 100 days until mid-July, when the majority of Hutu rebels had been defeated. So some 500,000 Tutsis were killed. And in the region of 2 million refugees, mostly Hutus, had fled into neighboring Tanzania, Uganda, and DRC as it is now, and Burundi. One of the measures taken by the international community was the establishment of the International Criminal Tribunal for Rwanda, which was November 1994 by a resolution of the United Nations Security Council. The Ictr was established to prosecute persons responsible for genocide and other serious violations of international humanitarian law committed in the territory of Rwanda and neighboring states. That was between 1st January 1994 and 31st December 1994, a period of 1 year. Interestingly, much as the tribunal was established at the request of the government of Rwanda, its establishment was later the subject of reservations from the government of Rwanda itself. The reservation arose when it came to the attention of the Rwandan government that the jurisdictional competence of the Ictr extended beyond just acts of genocide, and further that the government officials were precluded from being granted immunity. So when the government noticed that they would not have immunity over this, they started to have a second opinion about the importance of this particular tribunal, particularly the aspect of immunity. So the absence of immunity for government officials was a great disincentive, which immediately prompted the Rwandan government to enter a reservation with the United Nations. The offices and chambers of the Ictr were located in Arusha, Tanzania, with a satellite office, of course, in Kigali, Rwanda. And the tribunal started its work in 1995. Article 8 of the Statute of the Ictr, which is similar to Article 9 of the Statute of the former Yugoslavia, confers primacy of jurisdiction on the ad hoc tribunal. That Article 8 provides that the International Tribunal for Rwanda and the National Court shall have concurrent jurisdiction to prosecute persons for serious violations of international humanitarian law committed in the territory of Rwanda, and Rwanda's citizens for such violations committed in the territory of the neighboring states between the 1st January 1994 up to 31st December 1994. Paragraph 2 provides that the International Tribunal for Rwanda shall have primacy over national courts of all states. Of all states. At any stage of the procedure, the International Tribunal for Rwanda may formally request national courts to defer to its competence in accordance with this present statute and the rules of procedure and evidence of the International Tribunal for Rwanda. You can see a lot of similarities between this provision and that of the ICTY. There is the issue of concurrence of jurisdiction. There is the issue of primacy conferred upon the tribunal as opposed to the national courts. Very interesting. It would look like just a transplant and mere copy and paste, but that's not what happened anyway. It's just similarity of the drafting. Since its commencement, the Ictr had indicted 93 individuals suspected of having been responsible for serious violations of international humanitarian law in Rwanda during 1994. Among the inductees were high-ranking military officials, prominent business persons, religious leaders, politicians, media personalities, and members of the local media. In this way, as had the tribunal preceding it as the Ictr, why? The Ictr also focused on prosecuting high-profile offenders, leaving the lower level suspects to jurisdiction of the National Criminal Court, hence bringing the issue of impunity gap. With its sister international tribunal, the Ictr played very crucial pioneering role in establishment of a credible criminal justice system at an international level, and in the process generated a substantial body of jurisprudence on war crimes, crimes against humanity, and genocide, all crimes reflected in the Rome Statute. So it's clear that a big body of jurisprudence was being built by these tribunals, which have tended to help also in the interpretation of issues before the International Criminal Court. The last trial judgment of the Ictr was delivered on the 20th December 2012 in the Giravatware case. All the cases serving before the appeals chamber remained. Those are the cases that were still before the appeals chamber. The United Nations Mechanism for International Criminal Tribunal, the MICT, assumed responsibility for the residual functions of the ICTY on the 1st of July 2012. So that's the takeover time when the residual mechanism, international residual mechanism for the tribunals took over from the ICTR. The MICT, which is a term I'll use for the mechanism, assumed the key function of tracking down and arresting the three accused fugitives from justice on charges of genocide, crimes against humanity. We have Felician Kabuga, who was arrested not far back, not many weeks back, in a suburb in Paris. Protes Piranya Augustine Bizimana. Given the serious atrocities the ad hoc international criminal tribunals were dealing with, they needed a more than simple concurrent jurisdiction with national courts if they were to deal effectively with the alarming security situation. So much more than just concurrence was required. It is suggested that it was necessary to grant the tribunals extraordinary jurisdiction that would not be subject to unwarranted interference from vested interests in the national states. Like we've just seen, the issue of absence of immunity made Rwanda begin to re-examine its relationship with the tribunal. They thought that there would be immunity for government officials. So such was not necessary if we are to be able to. So it was necessary that the tribunal get extraordinary jurisdiction. Accordingly, it could be argued that extraordinary jurisdictional primacy granted to the ad hoc International Criminal Tribunal was justified in the circumstances. It is suggested that the degree of atrocities was indeed a threat to global peace and security. In effect, the situations in Rwanda and former Yugoslavia were seen as constituting a threat to the international peace and security. An important point worth making is that the statute of the ICTR provided that by undertaking prosecution, it was intended to make a contribution towards reconciliation within the Rwandan society. This expressly stated in the statute, where it provided in its 7th preamble paragraph that convinced that in the particular circumstances of Rwanda, the prosecution of person responsible for serious violation of international humanitarian law would enable this aim to be achieved and would contribute to the process of national reconciliation and to the restoration and maintenance of peace. That's where we see reconciliation meetings held, another alternative justice process that would enhance reconciliation. This statement reflects on the position of the ICTR statute regarding the distribution of jurisdiction in favor of an international tribunal. However, it could be argued that the statement is a mere preambular proclamation and would have carried greater weight had it been incorporated in the text of the statute. To summarize, having considered both the ICTY and ICTR, some comparisons can be made and conclusions drawn. It is noted that the two ad hoc international tribunals enjoyed jurisdictional primacy in the sense that they had the priority jurisdiction in respect of international crimes committed in the states that were concerned, irrespective of whether or not the national authorities failed to investigate or prosecute the suspected offenders. This underscores the tribunal's jurisdictional primacy over national criminal courts. Finally, it is equally important to observe that apart from their primacy of jurisdiction, the tribunal's jurisdiction was also designed to be concurrent with that of the national court. So there are two things. We have a concurrency of jurisdiction, but at the same time, there's conferment of primacy of jurisdiction upon the tribunal. It can be seen that the Ictr and Icty share a common feature in that both were created by the United Nations Security Council resolution, acting pursuant, of course, to Chapter 7 of the United Nations Charter. Unlike the Icty and the Ictr was created at the request of the government in the territory of which crimes had been perpetrated, namely Rwanda. Rwanda requested for the creation of the Ictr. That was not the case with the Icty. But as we saw, it later regretted why that happened, because it realized immunity that was contemplated was not being granted to the government officials. The Ictr and the Icty share a common appeals chamber at The Hague in Netherlands. The state of the Ictr, the statute of the Ictr, differs from that of the Ictr in many respects, notably the applicable law, subject matter, the temporal, personality, territorial jurisdiction, and organizational structure. This, of course, affected the way in which each of these institutions interacted with the relevant national jurisdictions when it came to the principle of complementarity. In conclusion, unlike the Icty, the Ictr, which enjoyed primary jurisdiction over the national authorities, as already indicated, the ICC is not based on the principle of jurisdictional primacy, but rather on the principle of complementarity, which is explored further in our other lectures that will come after this. So we see the ICC is anchored upon the principle of complementarity, while on the other hand, the Icty and Ictr are based on primacy of jurisdiction, which they have over the national concerned jurisdictions, authorities. Primacy regime. The primacy regime was designed to generate a jurisdictional hierarchy in which domestic jurisdictions retain the ability to prosecute perpetrators, but which preserves an inherent supremacy for the international tribunals. In this case, the national authorities still retained a right to prosecute offenders or exercise national jurisdiction, notwithstanding that the primacy of the tribunal was in place. So, in this regard, the primacy of jurisdiction appears to have been three key elements, namely concurrence of jurisdiction, hierarchy, and the power of the higher courts to decide on the issue of jurisdictional competence. As we saw, the appellate court the same court could decide whether there was jurisdictional competence of the court itself. So in summary, the Rome Statute elected to distribute jurisdictional competence by way of complementarity and not by primacy of the international tribunal. Apart from the twin international tribunals of the Ictr and the Icty, there were other international criminal tribunals that would generally be described as hybrid in character. It's now necessary that possibly this could also be examined. So what we're saying basically is that apart from these other tribunals, we had some others, and I'll just take about 2 minutes to quickly rush through to see what are these hybrid international criminal jurisdictions. Like earlier international tribunals, the hybrid tribunal had to provide for the distribution of jurisdictional competence. Apart from the Ictr and the Icty, other special courts were established to promote overall efforts in the fight against international crime. This group of tribunals is important in the context of positive complementarities as they provide a historical background to state efforts to combat impunity within their own national jurisdictions. So the mixed criminal tribunals represented a shift away from the structure of the Icty and Ictr to a hybrid model with both domestic and international components together. It's for this reason that they are referred to as hybrid or mixed tribunals, In the year 2000, these mixed criminal tribunals were set up in Sierra Leone, East Timor, Kosovo, Lebanon, and Cambodia. They represented a new regime designed to give impetus to the fight against international crimes on a domestic level. So in March 2000, the Serious Crimes Panel for the East Timor was established. I'll refer to that as CSCPET. And in July the same year, the Extraordinary Chambers of Cambodia, the ECC, were established. In August, the Special Court for Sierra Leone was likewise established. The so-called hybrid international criminal tribunals each exhibit distinct features designed to suit the peculiar circumstances obtaining in a given situation within a specific state. Let's quickly look at the Special Court for Sierra Leone. The agreement establishing the Sierra Leone, the Special Court for Sierra Leone, the SCCSL, provided that the court would have jurisdiction over certain serious crimes committed in Sierra Leone. This meant that Sierra Leone's domestic courts could prosecute only under limited circumstances. On the other hand, the constitution of the tribunal also promoted domestic ownership in the process, in that its judges were drawn from both the domestic and the international pool of judges. That's a very critical feature of these hybrid institutions. Judges would come from the local jurisdiction as well as from external countries, form a pool of judges. The conflict in Sierra Leone, unlike those in Rwanda and the former Yugoslavia or Cambodia, had no ethnic component. Because there was no ethnic component, the crime of genocide was not included in the crimes under the statute of the SCSL. The rampant crimes in Sierra Leone were perpetrated by rebels whose main aim was personal enrichment. It has been suggested that the armed conflict in Sierra Leone began with the Revolutionary United Front rebels headed by Fode Sankoh when launched armed incursions into the eastern part of the country on the 23rd March 1991. After protracted fighting, escalating rebel activity, and mounting international pressure on the president of Liberia, Charles Taylor, at that time, in June 2000, the government of Sierra Leone requested the assistance of the United Nations to establish a court to prosecute perpetrators of the civil war in Sierra Leone. The case of Sierra Leone appeared unique in that an independent special court, in preference to an ad hoc international criminal tribunal, was established. This was prompted by the need to adjudicate innumerable serious violations of law, international law within Sierra Leone. Because of the prohibitive financial implications involved, the United Nations Security Council was reluctant to establish the SCCL. Instead, in August 2000, the Security Council adopted Resolution 1315, requesting the UN Secretary General to negotiate with the government of Sierra Leone to establish an independent special court. The resolution provided that the special court would prosecute those who bear greatest responsibility for human rights violations. So during the course of the negotiations, jurisdiction emerged as a key question. The temporal jurisdiction of the CSCL provided contentious elements. It became contentious, with the distribution of jurisdiction taking on particular importance in light of the amnesties granted under domestic law pursuant to the Lome Agreement that we will recall. The Lome Agreement basically provided, for example, that in order to bring lasting peace to Sierra Leone, the government of Sierra Leone shall take appropriate legal steps to grant Corporal Fode Sankoh absolute and free pardon. In the end, the agreement establishing CSCSL provided bifurcated temporal jurisdiction, restricting jurisdiction over domestic crimes to crimes committed after 7 July 1999, while the jurisdiction over the international crimes extended back to 30th November 1996. Despite the argument that the Sierra Leone conflict began with the incursion of the RUF into the Sierra Leone, the Security Council Secretary, the Secretary General, of the United Nations opted to use 30th November as the date of signing of the Abjad Accord as cut off by the prosecutor. Well, to just cut the whole story short about this particular, the statute of the CSCL sets out 4 different types of crime over which the court has jurisdiction, namely crimes against humanity, war crimes, those are violations of common Article 3 of the Geneva Conventions and of Additional Protocol 2. Other sections concern the serious violations of international humanitarian law and crimes under the law of Sierra Leone. As a result, the SCCL is a treaty-based court as opposed to the ICTR and ICTY, which were established by UNC's resolution. The jurisdiction of the SCCL is a hybrid or mixed jurisdiction in the sense that both national courts and the special court enjoyed concurrent jurisdiction. An important feature of this concurrent jurisdiction, however, is that like the ICTY and the Sierra Leone court has primacy and may at any time the proceeding formally request the national court to defer to its jurisdiction. Similarly, the primacy of jurisdiction may be witnessed in that an individual who has been tried by the national court may still be arraigned before the SCCL if, for example, the national court failed to show independence or impartiality where the proceedings are regulated. In conclusion, the hybrid nature of the SCCL is reflected not only in the composition of the bench, which includes both international and local judges, but also in the jurisdiction over prescribed domestic international law. Finally, in conclusion over all these we observe that from the analysis that we've just provided of the International Tribunal, one may conclude that primacy has had no regard for the consent of the state before instituting prosecution. In other words, it was immaterial whether or not the state was willing or able to exercise normal jurisdiction. States increasingly feared that their sovereignty was being eroded. To get around this, it was necessary to devise a new jurisdictional relationship with the states to secure their state sovereignty, while at the same time not compromising efforts to fight impunity on an international level. The core issue here is how to deal with juridical competence, where both the domestic and international criminal jurisdictions are invoked concurrently to adjudicate over international crimes. In this regard, a historical survey of that tribunal sets a useful background for understanding the basis of the evolution and development of the concept of positive complementarity. And on that note, we come to the end of this lecture. Next, we're going to look at the negotiation and drafting of the history of the Rome Statute in our next lecture. Thank you very much. Thank you a lot. This is Professor Dr. Milton. As I said, I hold a PhD in international criminal law, and my doctoral research and other research revolve basically around the legal and institutional framework of the International Criminal Court. Thank you for listening to this lecture.